A lot of people who are in debt are severely stressed, that we know. One of the problems that we've identified on an ongoing basis is the lack of resources. And if there's something that emerges from the first session, it's the complexity of the situations that ultimately a lot of ordinary people find themselves in, and there isn't sufficient access to information and resources on an ongoing basis to help people along the way. People in debt are often exhorted not to act like the ostrich, don't stick your head in the sand, etc., etc. And that's all very well, but that advice often comes from people who are not over-indebted and indebted themselves. We conducted a study with the assistance of the Money Advice and Budgeting Service that culminated in a report called To No One's Credit in 2009. Debt didn't begin, obviously, with the recession. It's been going right through the 90s and into the noughties. One of the findings of that research which was about talking to people who'd had judgments obtained against them in the courts and who'd been brought down the instalment order road, an application for an instalment order to enforce a judgment. And a lot of people reported that at the time, they didn't understand the processes. They found it very difficult to read documents and very difficult to access clear information. Some of those people, though, had been interviewed and had emerged out of their debt difficulties thanks to the help of MABS and saw things much clearer than when they were in the financial situation itself. And I think that's something that's very important for everybody in this audience to understand. When you're in a very difficult financial position, you don't necessarily react rationally, logically, as some people would prefer you did. Now, I'm talking this evening about mortgage arrears and the Code of Conduct on Mortgage Arrears and the Personal Insolvency Act and how those two instruments might potentially work together to resolve the difficulties of people with a long-term arrears problem. The first thing that I have to say is, unfortunately, not very optimistic. A combination of the mortgage arrears resolution target mechanism set by the central bank, which Lorcan referred to earlier, the current revision of the Code of Conduct on Mortgage Arrears, it is being revised. You may have seen that. The finalised version we expect by the end of the month or early in June. And that, together with the Land and Conveyancing Law Reform Bill 2013, which has just gone into select committee, we believe will make an increase in applications to repossess family homes inevitable, that there will be an inevitable increase in applications in 2013, but certainly in 2014 and beyond. Why is this the case? Well, the mortgage arrears resolution targets set by the central bank, and Lorcan referred to them earlier on. Perhaps what he didn't say, though, was that the definition of a sustainable arrangement under those targets is the possibility of the voluntary surrender or repossession of the dwelling, as well as a sustainable arrangement to pay the mortgage on a long-term basis, or an arrangement under the personal insolvency legislation. The Code of Conduct on Mortgage Arrears, the revised version, makes it very clear that a lender has to consider a potential range of options for rescheduling the mortgage. Most of these have been short-term ones up to now, interest only, etc. The range in the revised code has been expanded, as we'll see in due course. But that code also, the revised code, very specifically says that the lender may declare the mortgage to be unsustainable. And I will be talking, obviously, in the course of the next 20 minutes about the appeals mechanism and what you can do as a borrower to appeal that. The last plank then is the Land and Conveyancing Law Reform Bill, which will be passed fairly shortly, we think, and which will reverse the effects of the so-called done judgment, gun and start mortgages, and will return the repossession scenario to pre-2009 and will allow lenders to use the summary procedure for the repossession of family homes. So the combination of those three instruments will, we think, make it more likely that there will be an increase in repossession applications. So what's in place to help indebted consumers? Bear in mind, we're talking about the principal private residence here when we talk about the Code of Conduct on Mortgage Arrears. It applies only to the principal private residence. To try and navigate your way out of this situation, firstly, you have to become acquainted with how the revised Code of Conduct on Mortgage Arrears will operate. And secondly, you will also need to know how that revised code and the Personal Insolvency Act 2012 will knit together, particularly the personal insolvency arrangement mechanism within the 2012 Act, which applies to secured debts. As I said, the CCMA is being revised at present. FLAC submission you can get on our website. It's fairly lengthy. In the slides that follow, I'm assuming that the code will remain as published in the revision. As I say, next couple of weeks, the finalised version will become available. There are some grey areas as well where the central bank has posed some questions which various organisations have responded to by their submissions, and it remains to be seen what decisions the central bank have made. But essentially, the Code of Conduct on Mortgage Arrears, for those of you who are not that familiar with it, obliges all mortgage lenders, with the exception of local authorities, and it was identified in the previous session that there are difficulties around local authority mortgages. It is the case that a number of local authorities do operate the Code of Conduct on Mortgage Arrears on a shadow basis, but they're not bound legally to apply it. Lenders must have a so-called Mortgage Arrears Resolution Process, or MARP, and that's a system that lenders must put in place to process arrears and pre-arrears cases, and we heard in the first session the number of households that have a fundamental mortgage arrears problem. The object of the Code of Conduct on Mortgage Arrears and the Mortgage Arrears Resolution Process is to resolve cases of arrears, not to repossess dwellings. And it is very important that people in arrears understand that that's the objective, and that advisors understand that in your dealings with a credit institution that you emphasise that the object of the exercise here is to find a resolution, not to repossess the dwelling. The repossession of the dwelling should be an absolute last resort. Now, I can't obviously go through all the features of the MARP rules here, time won't permit, so I've selected a certain number that I think are relevant to the decision-making process. First thing, given the fact that many people in debt don't have access to a solicitor, an accountant, even a money advisor, though the Money Advice Budgeting Service has done and continues to do tremendous work, it is under-resourced and can't cope with the number of potential clients. Some people, therefore, find themselves negotiating this problem on their own. But an important thing to remember is that the borrower may request in writing that the lender liaise with a third party nominated by the borrower. It doesn't have to be a legal representative or an accountant. It could be your next door neighbour. It could be somebody who you think has some expertise in financial matters and so on. The lender must comply with your request to be represented by a third party. But it is important to say correspondence under the MARP CCMA only goes to the debtor. So if you have nominated somebody, make sure to copy any correspondence to that person, because the lender won't send it to your representative. Under the MARP, you've got to fill out a standard financial statement. Under the Personal Insolvency Act, a prescribed financial statement. What is this? It's basically a statement of your affairs. To whom do you owe money? What's coming in? What's going out? It's the basis for making a decision about affordability, what you can afford, etc. We have certainly seen in the past, and many money advisors have seen this, inaccurate standard financial statements going into arrears support units, or the information not been properly verified or checked. So this is the information that is going to be used by the lender's arrears support unit to make a decision on your case. So it's vitally important that the financial information on the standard financial statement is correct in the first place and is kept updated. The lender must explore all options for alternative repayment arrangements. Now, note, in the revised code, all repayment arrangements that it offers, okay? And that seems to allow wriggle room for the lender to choose from the suite of options and maybe exclude others, such as debt write-off. Therefore, I think it's very important to ask your lender in advance, in writing, what options under the revised Code of Conduct on mortgage arrears for alternative repayment arrangements do you offer? The lender must document each option that it considers and must also document why a particular option that it selects for you was chosen. There's the range of repayment options in the revised Code of Conduct on mortgage arrears. If you can see the asterisks, can you see them from there? They're the new ones. Okay, so you've got interest only, which has been the primary weapon up to now to try to deal with the situation, but has only really been a short-term instrument and really hasn't resolved mortgage arrears cases. Reductions in interest rates, payment breaks, in other words, moratorium on payment, extending the term of the mortgage, changing the type of the mortgage, capitalising arrears and interest, any voluntary scheme such as a deferred interest scheme. But the really important ones in the game at this point, I think, are those last three. Equity participation, obviously potentially suitable for people who are not in negative equity and have some equity in their home, where the lender may take a percentage of the equity and thereby the principal amount owed on the mortgage is reduced and therefore so is the instalment. A split mortgage, you'll have heard perhaps of split mortgages. This is essentially an arrangement to split the mortgage into two parts. One part is serviced by the borrower, capital and interest, and the other part is shelved or warehoused and to be dealt with another day. One of the problems with split mortgages, though, is that some of the institutions, Bank of Ireland, ICS, Building Society, for example, charge interest on the warehoused part. And then 20 years, 25, 30 years down the road, you're faced with a big balloon capital sum to be paid, and you may be approaching your retirement at that point. This is considered to be a proposed sustainable solution under the central bank's mortgage arrears resolution targets. Okay, so the mortgage arrears resolution targets are fine, but how sustainable all the arrangements are is seriously open to question. Which brings me to debt write-off. The great unnamed, unnameable, but at least named for the first time in the revised Code of Conduct on mortgage arrears. For the first time, the central bank has named debt write-off as a potential alternative repayment arrangement, and we'll return to that in due course. It is crucial to understand that under the MARP, the lender is not obliged to offer an alternative repayment arrangement. It is only obliged to consider the possibility of an alternative repayment arrangement. It has to document its process and so on, but it can still come back to you and say, having given this due consideration, we believe that this mortgage is unsustainable and therefore we're not offering you a further arrangement. Now, there are many, many people who have been on interest only on a periodical basis for 3 months and then 6 months and 12 months and so on, who are now in a position where their mortgage will either be sustainable in the long term as a result of a further offer from the lender, or may be declared unsustainable with all the consequences that follows from that. You may therefore be offered an arrangement that you don't believe is sustainable. You may be offered a split mortgage arrangement by your lender that you believe puts you under enormous financial pressure for the next 20, 25 years and leaves the question of the capital balloon payment at the end unresolved. Okay? You can appeal either the lender's refusal to offer you an arrangement, or you can appeal the arrangement that you have been offered if you don't believe that it's suitable. Now, of course, you don't have to. And in some instances, certainly people will surrender the family home in their own belief that the situation is no longer sustainable and won't be in the long run. In that instance, the prospect of a debt settlement arrangement opens up for the borrower. A lot of these mortgages will be in negative equity. There will be a shortfall. For the purposes of the DSA, that shortfall is an unsecured debt. It ranks with your other unsecured debts, and certainly where properties are repossessed, we can certainly foresee a number of debt settlement arrangement applications being made on shortfalls on properties. Okay, so you're entitled to appeal in either of the two situations. You must be allowed, under the terms of the MARP and the revised MARP, at least 20 business days to appeal. The appeal is very important. Now, it is to an internal appeals board, so it's internal to the lender. Nonetheless, there is some evidence of decisions being overturned on appeal. In order to exercise your right of appeal properly, you've got to prepare for the appeal. Okay, so if you've been told your mortgage is unsustainable, you have to make a case as to why you believe it can be sustainable in the long run. If you're not happy with the arrangement that you've been offered, you have to make a case for putting an alternative repayment arrangement in place. And it is crucial that proper submissions and proper arguments are made to the appeals board. You have a further right of complaint externally to the Financial Services Ombudsman. We have spoken to senior officials in the Financial Services Ombudsman's office, and their belief, and the central banks indeed, is that the FSO's appeal is only about process. Did the lender follow the rules set out in the CCMA and the MARP? Was the borrower treated in accordance with the terms of the MARP? They'll take appeals on that. They will not, as we understand it, investigate the lender's decision not to offer an arrangement or the particular arrangement that was offered. In other words, the substantive decision the FSO will not rule on. Therefore, our conclusion is there isn't a proper right of external appeal under the Code of Conduct on Mortgage Arrears, and if you look at our submission, you'll see how that has been further argued. If all your appeals fail, internally to the appeals board, externally to the Financial Services Ombudsman, the lender may then issue legal proceedings against you or against the borrower for repossession of the family home. However, the lender must wait at least 12 months, which has become known as the 12-month moratorium, from the time it first formally notified the borrower of the arrears before the repossession proceedings begin. The notification must come 31 days after the first instalment is missed under the mortgage. Now, without getting too bogged down here, there is a difficulty. This is the third Code of Conduct on Mortgage Arrears that we're about to get. There have been people, according to the statistics, who've been in mortgage arrears right through from the first incarnation of the CCMA right up to the present day. Where are they with the 12-month moratorium? Nobody really knows. Okay? You are, though, according to the revised code, entitled to request from your lender in writing a summary of where you are in the 12-month moratorium. How much time has elapsed of the 12-month moratorium in your particular case? It is important to understand that the time negotiating and agreeing payment arrangements counts as part of the moratorium, which is absolutely unjust. If a lender drags their heels then in assembling the financial information and contacting you, and between the jigs and the reels, 4 or 5 months could elapse before an offer of an alternative repayment arrangement is made. That time is gone out of your moratorium according to the central bank. And again, we have said that this should be amended in the revised code. The time negotiating the arrangement should not count for the purposes of the moratorium. Time complying with payment arrangements does not count. So any time that you're in an agreed repayment arrangement with the lender, that does not count for the purposes of the moratorium. Neither does the time spent appealing a decision, either internally to the appeals board or externally to the Financial Services Ombudsman. Therefore, if you want to delay the possibility of repossession, I suppose the advice would be appeal and keep appealing until potentially your rights are exhausted. There are some proposals in the revised code around this where the borrower has been refused a proposed arrangement. The central bank is proposing that the 12-month moratorium will no longer apply, clearly after any appeals have been processed, and that the borrower be then given 30 days to consult a personal insolvency practitioner. In the event of the lender refusing to propose an arrangement at this point, the central bank has asked for submissions as to whether what remains of the 12-month moratorium should apply, or 30 days to consult a personal insolvency practitioner. A person in arrears to consult with a personal insolvency practitioner. Therefore, I would expect that those time limits are going to be squared up with each other. 1 month to talk to a personal insolvency practitioner is clearly not enough. Okay, I'm on the time as well. The PI Act as an alternative. You don't have to go right through the MARP process. You don't have to appeal the lender's decision, okay? Instead, you may short-circuit that process and decide to go to a PIP and apply for a personal insolvency arrangement. Or, by the way, for a debt settlement arrangement. The debt settlement arrangement cannot include secured debts, okay? But it is envisaged that if your only secured debt is your mortgage in arrears, that you might do a separate deal with the mortgage lender outside the terms of the debt settlement arrangement and propose that arrangement to your unsecured creditors. After 5 years, if your arrangement is accepted, unsecured debt is written off and you may go back to dealing with the mortgage. So it's not just a PIA that may be possible here, a DSA may be possible as well. To apply for a personal insolvency arrangement, though, in these situations, you have to make a declaration in writing declaring that you have cooperated for at least 6 months under the MARP and you've not been able to agree an acceptable payment arrangement, or the lender has declared the mortgage unsustainable. There are thousands of households in that situation right now who are much longer than 6 months in the MARP, and if they are now refused a long-term sustainable arrangement, may be entitled to turn to a personal insolvency practitioner for a remedy. Critically, though, you're back to the creditors' vote at the meeting, and much has been spoken about the veto. Personal insolvency arrangement, you've got to get at least 50% of your secured creditors agreeing to the proposal, 50% unsecured, 65% in total, and the DSA, at least 65% of your creditors in value must approve your proposal. Very quickly, some reasons why you might want to bypass appealing under the MARP. If you've got substantial debts, both secured and unsecured, and you need a binding settlement with all of your creditors, you might want to go to an insolvency practitioner quicker. Now, Lorcan mentioned the pilot mentioned by the central bank during the week. One of the problems with that pilot, as some of you who've read the news will see, is that it really annoyed the Irish League of Credit Unions because it doesn't consider unsecured debt remotely near the same priority as secured debt. And this is one of the huge problems with all of these instruments, is that unless you're dealing with all debts simultaneously, it becomes very difficult to get a solution. But if you get a binding settlement with all your creditors, at least the balance of unsecured debts will be written off at the end of the repayment period. It is said that creditors may be more inclined to accept a proposal from an independent professional person. That remains to be seen, but that's very much one of the things that the government is saying. Creditors will also know that behind refusal is the prospect of bankruptcy, and we have heard a lot about that already. Some reasons you might not want to bypass appealing include that you've very few saleable assets and little disposable income above the guidelines allowed by the Insolvency Service, and it may be therefore very difficult to get a personal insolvency practitioner to take on your case, and even if he or she does, the chances of acceptance may be slim, because you're going to be looking for a better deal, generally speaking, than the mortgage lender has already offered you. And ultimately, your creditors decide at a creditors' meeting on your proposal, and there's no appeal for you. So if you make the proposal and it's rejected, then the prospect of bankruptcy looms large, and again, that involves the potential, but not necessarily the loss of the family home. Very quickly, some practical matters. If you're on your own or if you're assisting somebody with a MARP, open your own MARP file. Make sure the process is documented at all times. Keep telephone contact to a minimum. Make a note of any telephone conversations that you do have. Note all unsolicited communications, which must not be excessive, aggressive or intimidating, but the limit of 3 is now gone. Follow up any calls, meetings with your understanding of decisions. Find out who's in charge of the ASU and correspond with him or her. Note any lack of cooperation, delay or inconsistency on the part of the lender, because the lender is obliged to cooperate under the MARP as well, and you have rights of appeal as mentioned. If you find these processes unsatisfactory and unsuccessful, report it to your local TD, to the central bank, to the Minister for Justice, to FLAC, because these measures are supposed to be put in place to minimise repossessions and find debt resolutions. And if they're not working, then they need to be changed and changed quickly. And lastly, I just want to quote from the Minister himself, speaking at the Law Society annual conference last week. He said that the PIA will be of particular use for those persons experiencing difficulty with the repayment of their mortgages. I expect that PIA solutions in many cases may have to provide for appropriate debt forgiveness. If they don't, the legislation won't work. Thanks very much indeed.